Free Quickie! Let's look at a good Supreme Court case, 1964's New York Times v. Sullivan. Supporters of Martin Luther King took out a full-page ad in the New York Times in 1960, where they criticized various public officials for violating civil rights. L.B. Sullivan, a police commissioner in Montgomery, Alabama, sued for defamation. The jury awarded him $500,000 in damages, which was upheld by the Alabama Supreme Court. But the Supreme Court found 9-0 that this verdict violated the First Amendment. This was a big win for freedom of speech and freedom of the press, and it set the standard when dealing with public figures. If you're not a public figure, all you have to do is show that the statements were false and caused damages. Public figures are different, because we absolutely need the protections of the First Amendment to protect our right to criticize them, something that goes back even prior to the Revolution. So when you're dealing with public figures, two things would need to be shown. The first being actual malice. The defendant knew or should have known the statement was false or was made with reckless disregard for the truth. This was the case. What the New York Times had published was absolutely untrue. Claims about the number of times King was arrested, that students were expelled or padlocked in the dining hall, and even what song was sung by protesters were all incorrect. They also placed the burden of proof on the plaintiff to establish that. But there's a second requirement too. Ideas, generalities, theories, hyperbole, opinions, and so on are not actionable. You have to make a factual claim about a specific individual. Sullivan wasn't mentioned by name, but he claimed that that didn't matter since he was included in the people they were criticizing. But they had just used the generic term police, or the even more generic they. And the court found that that just isn't specific enough. As Justice William Brennan wrote in the opinion, "Thus we consider this case against the background of a profound national commitment to the principle that debate on public issues should be uninhibited, robust, and wide open, and that it may well include vehement, caustic, and sometimes unpleasantly sharp attacks on government and public officials." He also wrote, "This proposition has disquieting implications for criticism of governmental conduct. For good reason, no court of last resort in this country has ever held or even suggested that prosecutions for libel on government have any place in the American system of jurisprudence. We hold that such a proposition may not constitutionally be utilized to establish that an otherwise impersonal attack on governmental operations was a libel of an official responsible for those operations. Since it was relied on exclusively here and there was no other evidence to connect the statements with respondent, the evidence was constitutionally insufficient to support a finding that the statements referred to respondent." We have to be able to criticize government actions and policies, and they need to grow a thick skin rather than pitch hissy fits and take action against the speakers.